In this lecture series, we would like to discuss another important landmark judgment, that is the leading case Unnikrishnan vs.State of Andhra Pradesh in 1993. So, the very case relates to the position of right to education, then right to establish educational institutions, and relating to capitation fees and the very difference in between government and private educational institutions, in particularly relating to professional educational institutions, and how far as under Article 19 Clause 1 Subclause G, which provides the very right to freedom to carry out any trade, business, occupation, and profession, whether to establish educational institution as a fundamental right, falls within the category of profession, and the very validity of charging capitation fees by the private educational professional institutions. And in relation to that, we would like to discuss the fundamental rights as portrayed under Part 3 of the Constitution, vis-a-vis the directive principles of state policies as enshrined under Part 4 of the Constitution, and would like to make reference in that connection to Andhra Pradesh Act of 1983 and the Karnataka Act of 1984. Why? Analyzing and discussing Mohini Jain case, which already we have discussed in our previous lecture, and the next important leading case that we will discuss in this portion, Express newspaper case, Bandhu Mukti Morcha case, Olga Tellis case, Bangalore water supply and Sweres board case, and Bharat Sevashram Sangh case. So, in light of that, we would like to discuss the very provisions as relating to Section 3A of the Telangana or Andhra Pradesh Educational Institutions Regulation of Admission and Prohibition of Capitation Fees Act 1983, which was introduced in 1992. The private engineering colleges demanded that they have the power to admit students to the extent of half of the seats based on their choice, with no regards for merit. The admission will simply be on the grounds of them qualifying the entrance exam, and this led to basically right to impose a hefty capitation fee as they wished without any regulation. This created unrest among the students and teachers, who then protested against such admission. The government was unable to ignore the extent of the unrest and pressure the private engineering colleges not to make any admissions unless and until clear rules were drafted as per the provisions of Section 3A of the Andhra Pradesh Act of 1983. The engineering colleges opposed the order on the grounds that they had already made admissions based on their choice to the extent of 50% of their seats. These particular admissions led to a series of writ petitions in Andhra Pradesh High Court. A full bench of the Andhra Pradesh High Court allowed the said writ petitions and declared Section 3A as constitutional. It stated that the admission made by the private engineering colleges to the extent of half of their seats based on their own choice is absolutely illegal. The High Court further held that the government order that granted permission to 12 medical colleges and 8 dental colleges was invalid in its essence. Considering this decision and the order of the Andhra Pradesh government, the students who were admitted by the management came to protest the decision and filed multiple special leave petitions before the Supreme Court of India. So the very judgment of the High Court of Andhra Pradesh, which led to similar petitions, were filed across many other states in India. Since the issue involved in the case were national issues, all the states were invited to file representation by the apex court, even though notice was sent to all the states of the nation to appear in the present case. The ones that appeared in the case were the states of Andhra Pradesh, Maharashtra, Tamil Nadu and Karnataka. All the matters present in the important leading case, J.P. Unnikrishnan case, were concerned largely with these 4 states. So, in that connection, the Supreme Court of India relied on the previous certain precedents decided by it, in particularly the most important decision delivered in 1992 in the leading case Mohini Jain vs.State of Karnataka. So, wherein particularly the apex court made the observation as regarding the judgment stated that the writ petition filed by the private educational institutions that intend to impart medical and engineering education challenge the correctness of the decision given by the learned division bench in the case of Mohini Jain vs. State of Karnataka in 1992. Here the petitioners were those who ran medical and engineering colleges in states of Andhra Pradesh, Karnataka, Maharashtra and Tamil Nadu. They contended that if the decision in the Mohini Jain case was considered to be right and was then implemented in various state governments, the institutions should be forced to shut their operations and no other alternative would be left for them. The apex court therefore believed it is important to first ascertain what truly the decision of the Mohini Jain case. So, the state legislature of Karnataka government, which enacted the Karnataka Education Institution Prohibition of Capitation Peace Act 1984, was raised as under the very concerned sections in this important leading case. So, which in particularly we have already discussed in our previous lecture in detail. So, here only we would like to discuss in short. The case began when Miss Mohini Jain, a non-Karnataka student hailing from Meerut in Uttar Pradesh, applied for admission in MBBS course in a private medical college in Karnataka. The college informed her that she was supposed to pay Rs 60,000 for the tuition fee of the first year and provide a bank guarantee for the fees payable for the remaining years of the course. Considering that her parents were not in the right financial conditions to pay the demanded amount, she was denied admission. Mohini Jain stated that she was asked to pay a capitation fee of Rs 4,50,000 for getting admission into the institution, but the educational institution denied any such demands being made. Mohini approached the court under Article 32 and challenged the notification of the Karnataka government requiring separate fees for Karnataka and non-Karnataka students. She prayed for permission to be admitted by paying the same fees as was payable by the Karnataka students admitted to the government seats. The court considered the legal issues and held that based on the principle set by Article 21, Article 38, Article 39A, Article 41 and 45 of the Indian Constitution, the drafters of the Constitution intended it to be mandatory for the state to provide education to all the citizens. It was observed that the objectives which are mentioned in the preamble of the Constitution cannot be fulfilled without education being provided to all citizens of the state, and the dignity of an individual cannot be properly assured without provisions of education. It was stated that Part 3 and Part 4 of the Indian Constitution are supplementary to each other, and the right to education as envisaged by Article 41 of the Directive principle of state policy must be turned into a reality to provide full effect to the fundamental rights mentioned in Part 3. Without education, fundamental rights cannot be properly enforced or utilized by the citizens. Based on the capitation fees, the court stated that they were nothing but a mere consideration for receiving admission and facilitating the commercialization of education. The concept of commercialization of education has not been envisaged in the Indian Constitution, and therefore education cannot be commoditized for sale in India. So every citizen has a guaranteed right to education under the Indian Constitution, and the state is mandated to create educational institutions for all citizens to avail the right. The state is allowed to fulfill the obligation through state-owned or state-recognized educational institution. Further, the apex court in the important precedent that is relating to the very important leading case, and that is Express newspaper Private Limited vs. Union of India in 1959. Previously, the apex court held that the freedom of the press is a fundamental right arising from the right to freedom of speech and expression, as provided under Article 19, Clause 1, Subclause A. Moreover, a distinct set of rights have been drawn from Article 21 of the Constitution, which includes right to free legal and speedy trial, the right to adequate means of livelihood, the right to dignity and privacy, right to health, and right to a pollution-free environment, amongst many others. So Article 21 is an umbrella for other rights that are not explicitly mentioned under the fundamental rights but are equally crucial in maintaining the right to life and personal liberty. This includes rights such as freedom of press, right to adequate means of livelihood, right to education, etc. While the article is phrased in a negative manner, it was intended to have a broader interpretation to include a variety of rights which constitute the true realization of personal liberties. While Article 19, Clause 1 deals with a particular set of rights necessary for human life, the residual rights which are not mentioned in Article 19 are covered by the broader interpretation of personal liberty as provided under Article 21 of the Constitution. This interpretation has been sustained in law for quite a long period of time. And now we'll discuss another important judgment delivered in this connection in the Olga Tellis case. The apex court then referred to the judgment of Olga Tellis vs. Bombay Municipal Corporation in the year 1985, where it stated that the interpretation of the term life has to be expansive and broad to truly fulfill the objectives of Article 21 in the scheme of the constitutional principles. So the apex court referred to the part of the judgment which stated that the wings of the right to life which is guaranteed by Article 21 cover a lot of aspects. It simply does not perceive the physical existence of life which can be taken away through a death sentence or any other procedure established by law. The physical and literal meaning of life is merely one aspect of the right to life, but other rights arising from it, such as the right to livelihood, also form an equally important part of the fundamental right. Anything that makes life and living sustainable and is necessary for the continuation of a meaningful life of dignity must be considered to be a part of the right to life in an integral manner. When a state is obliged to secure adequate means of livelihood for its citizens, it would be unfair to exclude the same right from the realm of fundamental rights, especially the right to life. Further, the apex court referred to another important precedent and the decision relating to Bandhu Mukti Morcha case. And this particular important leading case, Bandhu Mukti Morcha vs. Union of India in 1984, as it was referred here, to substantiate how precedent shows that fundamental rights, especially Article 21, must be considered through the lens of directive principles of state policy. The apex court reiterates the part of the judgment which states that the right to live a life of human dignity is ingrained in Article 21 and derives its essence from directive principle of state policy, especially as provided under Article 39 and 41 of the Constitution. Based on this decision, the Supreme Court reached the conclusion. And before that, we would like to discuss another important leading case, that is Bangalore water supply and Suez wood case, and also another important judgment delivered by the Supreme Court in Bharat Sevashram Sangha case. So, in that relation, would like to discuss the past important and the major important leading case. That is Bandhu Mukti Morcha case. The court held that the right to life as guaranteed by Article 21 encompasses educational facilities within its expansive purview, considering the ultimate importance of education in life of an individual and the nation at large. The apex court agreed to the reasoning of the judgment made in Bandhu Mukti Morcha case that the right to education arises from the right to life as mentioned in Article 21. The right to education is unignorable importance in an individual's life, and it has been recognized in India and the world for decades. So, in relation to the last most two important leading cases that we would like to discuss, one is relating to Bangalore water supply Swiss wood vs. the state of Karnataka. So, in particularly, as relating to that, we found the very judgment in that important leading case, and that is relating to the very provisions in that particular decision which relates to exactly in that particular leading case we found the first decision cited was the decision of Bharat Sevashram Sangh vs. State of Gujarat in 1986, wherein it was held that Section 33 of the Gujarat Secondary Education Act 1973 empowered the government to take over the management of an educational institution for 5 years or less in specific circumstances. The aforesaid section was held to be constitutional as it was in the interest of general public and not violation of Article 19, Clause 1, Subclause G. Based on this decision, the Supreme Court stated that this decision was relevant to the present case as it did not say anything about education being a profession, occupation, trade or business. So the petitioners, as they placed the precedent or the decision of the leading case Bangalore water supply and Suez wood versus or Rajappa and others, a decision of the apex court decided in the year 1978, wherein it was held that educational institutions would fall under the ambit of the term industry. So, analyzing all these decisions, as we found in particularly in those important leading cases that were either cited by the petitioners and in particularly the Supreme Court or the apex court in this connection made the final and decision relating to such institutions and having the right to education. So the apex court at this point of the judgment refers to additional affidavits filed by the Union of India which dealt with the status of primary and upper primary education in India. The affidavit stated that there has been a significant increase in the enrollment rates in primary schools which has made India one of the largest educational systems in the world. The Supreme Court stated that the state must, under the command of Article 45, and make it a reality before the end of the century. The court further stated that this promise could be fulfilled not only through state schools but also through recognizing and aiding voluntary non-governmental organizations that are ready to impart free education to children. Further, as under Article 46 state that children belonging to weaker sections of the society also have the right to education. So, these are the important leading cases referred by the petitioners, or as it was discussed in this important relevant leading case, in particularly relating to right to education and in particularly right to establish educational institutions, whether they are falling under Article 19 Clause 1 Subclause G and the very position regarding charging capitation fees by the private educational professional institutions, in particularly engineering, medical and dental institutions. So, in relation to that also we made reference to Andhra Pradesh Act of 1983 and the Karnataka Act of 1984, and in short we have in brief discussed the rulings of Mohini Jain case, which we have already discussed in our previous lecture. As Mohini Jain vs.State of Karnataka in 1992. Then we have discussed the rulings of Express newspaper case and Bandhu Mukti Morcha case, Olga Tellis case, Bangalore water supply and Suez board case, then Bharat Sebastan Sangh case relating to Gujarat. So in our next part, we would like to discuss some other important provisions, and that in particularly relating to those provisions we found under fundamental rights, directive principles of state policy, than the Andhra Pradesh Act and the Karnataka Act, and also the University Grant Commission Act of 1956 and the Medical Council Act 1956 and the All India Council for Technical Education Act 1987.